There was a case very recently where a very high-profile civil contractor, which is a member of the Civil Contractors Federation, so I know them well, they were engaged under one of these contracts by Carrara Mining. It's published, so I can name the parties, but they missed their time bars. They'd missed their time bars. And the works were varied to the extent that from an original $24 million contract price, there were $24 million worth of variations. So the scope had doubled in dollar terms. So they hadn't missed their time bars. So they engaged lawyers to find all these clever ways. They raised estoppels and all sorts of things to try and circumvent the effects of these time bars. And in the meantime, they got an interim adjudication award, which is one of those rough and ready pay now, argue later systems that's designed to put money back in the contractor's pocket so that the risk of being out of pocket pending determination of the underlying disputes and claims shifts back to the principal instead of the contractor. Because as I said to you earlier, these contracts shift that risk onto the contractor. So they got their award, their interim award, and the litigation took 9 years. So 9 years after Carrara Mining was sued, it finally went to trial. The trial went on for 50 days, which is an enormous amount of time for a trial. Most trials that I do, and I'm trial counsel in the cases that I conduct. I've done many trials, and I usually close my case within 5 days. 5 to 7 days is typical for a fully contested trial on issues that should have been narrowed in mediation conferences and all sorts of things that you have to go through in order to really focus and narrow the issues. By the time you get to trial, you can knock out all the evidence, close your case within about maximum 10 days. So this went on for 50 days. It was an enormous case. The judgment was 1,000 pages. And basically, they failed completely. The contractor failed completely. They got none of the $24 million worth of claims that they'd made. They were liable for liquidated damages to the full extent of the claims that were made against them. They were ordered to repay the adjudication award that they'd recovered 9 years earlier. They would have paid, I should fully expect, they would have paid millions of dollars in legal fees. They would have been liable to pay millions more in costs to the other side. They had multiple experts. Those people needed to be paid. The expert witness costs of the other side would have had to be reimbursed, at least partly. Enormous cost to them for not having met time bars. And arguments about unfairness and clever legal arguments to try and circumvent these contract provisions were all tested. It was actually quite a valuable test case because it tested a lot of the propositions that I'm putting to you tonight.